Okay, well, good afternoon, just barely afternoon by my time slot. My name is Jason Hanford. I'm an attorney at the Chartwell Law Offices, and welcome. Hello. We hope that everybody who's signed on and is signing on is doing well. It's been a long year or so, which I'm not going to rehash, but we hope everybody's healthy, gainfully employed, and is working through in today's subject, the workers' comp system, as well as can be possible. So what we're doing today is as succinctly as possible an overview of the workers' compensation system in the state of South Carolina. This is a nuts and bolts 50,000 foot viewpoint overview. This is not the I've been doing this for 20 years. Why don't you tell me what I should learn in my 21st year? This is the hey, I just walked in the door. Tell me how these claims are handled in South Carolina. Why am I here? My name is Jason Hanford. I'm an attorney in Philadelphia, Pennsylvania. I more than likely know less about South Carolina workers' compensation than any of you who are participating as guests today. So I'm on this journey with you. I'm really just here to facilitate and to ask the questions that you might have. And we're going to learn how the system works there. So we've got a really good panel. I want to get to introductions in a second. Before I do, we have some disclaimers that we always do, just to make sure that we're all on the same page. Today is not a continuing education session, so there's not going to be any passwords or special names that you have to write down, but we do ask that you stick with us and get all the information you can. If you have questions, and I hope that you do, because I'll have lots of questions, you should see at the bottom of your Zoom screen a Q&A section somewhere. And that is where we want you to put your questions and answers. You put your questions there, we'll answer the questions. Some people like to put their questions in the chat section. That's harder to get to. We'll certainly get to any chat questions you have, but if you could keep any questions in the Q&A section, it's easier for me to find them. Use the chat section to, make fun of my hair or something more useful like that. What else do we have? The last disclaimer that I always give, and I'll do it for Leslie and Woody and Jen too, this is not legal advice. So we're not telling you what to do with your claims specifically. If you need specific legal advice for South Carolina workers' compensation claims, I would strongly suggest you talk to Leslie about that, and we'll give you her contact information. But don't go make bad decisions today based on what we say in the next hour. We're just giving you an overview. With that said, I want to, and also I got to put a plug in for the firm. Leslie and I both at Chartwell Law. We're partners there. We're in, 12 to 14 states now, including obviously South Carolina. Please go to the website if you have any questions about workers' compensation in South Carolina. Contact Leslie if you have questions about South Carolina. And if you want to find out about other states, check out the website. We're always happy to talk. All of that fun stuff out of the way. My partner, Leslie Whitten, is participating today. We also have Jennifer Taylor from Strategic Comp. She's a senior claims specialist there. And we have Woody Doossche, the Director of Safety and Risk from Charleston County School District. They're all going to talk more than I am. I'm going to kind of pipe down now, but we got to keep it moving because we're 4 minutes into it, and I think we're going to take at least an hour to get through all this stuff. So, Leslie, I want to kick it over to you. The first place to start is the easiest place to start, sort of the elevator pitch. What's a general overview of how the system works in South Carolina?
Sure. So like a lot of states, South Carolina is a no-fault system, which means if your employee gets hurt and it's 100% their fault, they could have avoided, it's still going to be compensable. And compensable just means they're entitled to benefits under the Workers' Compensation Act. So that's the first barrier. And this started in 1911. That's probably too much technical information, but basically it's meant to be a compromise so that an employee can't go sue their employer in tort. If it's the employer's fault, say the employer, spilled oil on the ground and didn't put up signs or whatever, and the person fell, the employer can't be sued for that. But at the same time, the employee can't get benefits like pain and suffering and things like that. It's very limited. And we'll talk a little bit more about exactly what benefits you can get a little bit later. As far as the just how it's all handled, it's the Workers' Compensation Commission, and they're located in Columbia. And there are 7 commissioners, and they are appointed by the governor, and they have to be confirmed by the Senate. And right now, we've just reappointed 3 of them. They have 6-year terms, but they very often get reappointed. That there's one commissioner who started the same year that I started in 2002. So she's been there quite a long time, and that does tend to happen. They rotate jurisdictions every 2 months. So you never know. I mean, I can't tell you who's going to be in the Charleston area 6 months from now. We just don't know that yet. So it's every 2 months, just mainly so that it's considered fair, and the more liberal commissioners are here sometimes and the more conservative ones are here sometimes, and they get to know the whole state, and we get to know all of them.
My first out-of-towner question, are these, it sounds like they're based in Columbia, but they travel throughout the state. Are you going to see them for live hearings, or is it telephonic? Is it by video? What's the setup?
Sure. So yes, they're live hearings. They always have been live hearings. After COVID hit, there were a couple of months when they just canceled all hearings. And they had, if there were emergency hearings, they had this court call system where you could pay a lot of money and do the hearing over the web. That didn't last very long. So we went back, I want to say in May, to live hearings. There's, everybody has to wear masks and distance and, have the Purell or whatever, all that kind of stuff. But we've definitely been doing it live since then. Settlement conferences are different. Settlement conferences used to be live, and that would be whether they have an attorney or not. If they don't have an attorney, that's with the deputy commissioner, and it's called an informal conference. And if they do, it's with one of the 7 commissioners, and that's a clincher conference. Right now, they're doing all of those by phone, and I suspect they're going to continue to do that even after all of the COVID stuff is over.
Woody or Jen, do you guys participate in any of the, especially the telephonic procedures, or do you leave it to the attorney such as Leslie to participate and follow up with you afterwards? How common is your involvement there?
It depends. For informal conferences, there needs to be a representative, because sometimes the commissioner will award something that's more than the adjuster gave authority for initially, or it might be outrageous or something that you actually don't want to agree with. And really the adjuster has the final say so. So for informal conferences, representatives are always there. For clincher conferences, we've usually gotten that far because most parties agree to what's going on. So I usually turn that over to my defense attorneys, and I'm not present at that.
So I started attending informal conferences in person with my adjuster. I just feel like as an employer, you want to be there for your employee. And so I attended those. Now that they are over the phone, I let the adjuster handle that, and I give them authorization up to a certain amount. And then if there is a question or, a concern, then the adjuster will just call me or get me involved. Any other clincher conference, mediation, or hearing, I attend all of those in person with my defense counsel.
Leslie, just to circle back, and I'm sure we'll get to this later, but I want to try to define these terms as they come up. I think most people can infer from context what a hearing, what a mediation is. A clincher conference, it sounds to me like somebody's winning or settling, or what's happening there. What's being clinched?
Yes. Yeah, and I think I may have misspoke just now when I said clincher conference is where they're represented. I may have said that. If I said that, that's not true. A clincher conference just means you're closing out the case. So for that to happen, if the person is unrepresented, that has to be something that a jurisdictional commissioner actually approves. So if I settle a case with one of Woody's employees and they don't have a lawyer, and we're closing that out, we can't just decide to settle it. We have to actually have a 5-minute settlement conference before whatever commissioner is in this jurisdiction at that time, and get them to approve it. And they just explain their rights and make sure that they know that the case is getting closed out and that kind of thing.
It was the perfect segue. You said jurisdiction. And I think we've now kind of set the scene for how these things might be litigated eventually. But obviously, and unfortunately, before you can litigate a work comp injury, you have to have an actual or alleged work comp injury. So jurisdiction, Woody has an employee that's unfortunately injured or alleged to be injured. Jen gets involved as a claims adjuster. How do you determine whether it's an actual South Carolina workers' comp injury? What's the first steps that you're looking at?
So someone can bring a claim in South Carolina if they were injured in South Carolina, if they were hired in South Carolina, which is a little bit weird because that could mean they were on the phone in South Carolina, their employer is in Alabama, and they actually go work in Alabama, but it can still technically be brought in South Carolina. That's a really odd one. And then if the employment is located in South Carolina. And it typically, the insurance adjuster or the employer would just file what's called a first report of injury in South Carolina, and it would just be here. But at some point down the line, that could be switched if the employee decides to bring a claim somewhere else.
Assuming we're meeting those thresholds, the location of hire, location of work, that sort of thing, what are you looking at to see if it's a compensable injury? And I know in some states you can have injuries that aren't compensable, that, you know, it's just a dust it off and go back to work sort of thing, which we don't see much in our industry, but I assume they happen, Woody. What forms the basis for a compensable injury in South Carolina?
Yeah, so the way that I explain it at new employee orientation, I speak in front of all of our new hires every week. And when I explain workers' compensation, I try to keep it as simple as possible. And maybe I dumb it down a little bit too much, but I basically tell them that if you are injured within your scope of work during school hours on a school function, that would be considered a compensable claim. Now, whether they can prove that or I can find out whether what they're saying actually happened, that probably is the bigger question that gets argued than the actual injury itself.
And what
so injuries arising out of employment is what you're looking for, or occupational diseases, which are a result of employment. So that's your, that's your carpal tunnel, your repetitive stuff, exposure, inhalation, things like that. So as an adjuster, you're always looking for something that arose out of employment, rather than something that just happens because you happen to be at work that day. So that's where it can get a little iffy about idiopathic injuries or something that, was pre-existing or what have. Compensability is defined by injury arising out of course and scope of employment.
You raised what I think is a common issue in many states there. Between, you mentioned directly repetitive use and what I'll call an acute injury. I think it's much easier to show, I had this acute injury, it's course and scope of employment, pay me my money, than it is with repetitive use. Is there a different burden in South Carolina, Leslie? Is it you go about handling the case differently for repetitive use and or occupational disease?
Yes. So occupational disease and what we would call injury by accident, which is what you think of as you're walking down the you fall or something. Those two have been around for a really long time. And an injury by accident actually requires that an accident happen. And so for the longest time, we would argue that something like carpal tunnel syndrome wouldn't be compensable because that's not an accident. That's just something that happens over time. So in 2007, we had a huge overhaul of the legislation in South Carolina for workers' compensation, and they just added an entire section for repetitive trauma claims. And they do have very specific requirements. The employee has the burden to prove that they first have some sort of repetitive job that they have to do. So it can't just be, I type for a few minutes every day and now I have carpal tunnel. You have to actually prove that there's something that you do that's repetitive. And then you have to have medical evidence showing that what you're doing that's repetitive at work actually caused the injury that you have. And by medical evidence, the statute says that means that a doctor has to say to a reasonable degree of medical certainty, whatever the issue is, the carpal tunnel syndrome is caused by whatever the repetitive action is that you're doing at work. Frankly, it's not that hard to get doctors to say that, but they still have to go through that process.
Okay, and I think I just pulled up the Q&A, so a good timing from everyone. The first question was about injury by accident and whether South Carolina requires injury by accident, like in some other states. And it seems like the answer is that, injury by accident is a standard, but you can have the other standards. You just have to prove more to get that accepted. The other question that came up, and maybe Leslie, we can just address this very briefly. It has to deal with what you just mentioned about jurisdiction. The scenario being, if it's somebody who lives in South Carolina, but they have an employer in North Carolina, does the employee have the right to choose jurisdiction? It's the old law school long arm statute stuff that everybody fears and loathes. In Pennsylvania, we don't have this issue often because everybody wants Pennsylvania jurisdiction. How does it work down there in South Carolina? Do you have a lot of border issues with employees in one state trying to go get claims in the other state?
Yes, I'll Jen shaking her head. Yeah, I have one right now actually, because the person worked primarily in the upstate in South Carolina, but they were in a car accident in North Carolina, very close to Charlotte. So it's been handled in South Carolina the entire time, but now they have a North Carolina attorney who wants to move the jurisdiction. So yeah, that absolutely happens all the time. I am not sure, Jen, I don't know if you know, I'm not sure if North Carolina has the same jurisdiction rules as South Carolina, but I think it's pretty close.
They do. It's live, works, injured, hired. So you basically, I mean, you can direct it if it meets more criterias in one state than the other, but you also can give the claimant jurisdictional right if you want, if you think it's going to bode better for you as well. So, and honestly, both jurisdictions they're very similar, frankly. I mean, so I don't see a huge difference in South versus North. There are some nuances and some things that are different, but they're both pretty similar in the right that you get to direct medical care. There's PPD ratings at the end, so.
Yeah, South Carolina statute is actually modeled after North Carolina, so that.
Yeah.
And I think it's a timely question in that we're probably going to see more and more of this going forward when we have people, perhaps not Woody's workforce, they're probably more in person, but we have people that are telecommuting, that are working from home more and more and more. We're not going to spend any time on that, but I think everybody knows what we're referring to there. So let's talk about defenses. I'm a workers' comp defense attorney. This is exciting. Woody has a claim. We can't squirrel away from jurisdiction. What are we going to do? Leslie, Jen, Woody, what are the defenses are we going to look at?
Oh my. Well, I mean, first, you look for credibility, you look for red flags. So, and there's just so many. So, if somebody works Monday through Friday and they have the weekends off and Monday morning, they're alleging injury first thing, that's a red flag. If somebody has credibility problems or employment problems, or they're on final write-up, or, they've only been employed for 90 days and they're already filing a claim, or they have a history of claims. For me personally, as soon as I get a claim, I run a index to see priors, and I just attack it from there. So I know during my recorded statement what I'm looking for, and if they're going to be honest with me about that. But defenses, so commissioners are very pro-claimant. Anybody who handles workers' comp knows that. So defenses need to be pretty strong to prevail most of the time. So, you're looking for those red flags and surveillance and just anything you can to stack, because the idea is that you don't have to get to mediation. You don't have to get to a hearing, because during the deposition, we already have enough information that we're going to nail them. And someone like Leslie's going to let their attorney know, hey, look, let's get this done. And they know, claimants attorneys know if their clients present well. We're not afraid to let them know some of the evidence that we have against them. Sometimes you don't want to let them know. It's always a case-by-case basis. But as many defenses as you can stack, you need to in these jurisdictions.
Yeah, you never know what's
Leslie,
gonna stick, so.
yeah, Leslie, I wanted to ask you some legal-ish questions on that, but before I do, Woody, employer's perspective, obviously the best work injury is the one that never occurs. How proactive can you be as a South Carolina employer in anticipating some of these things that are going to come up? And I'm just looking at the list, and there's, willful intent, intoxication, that sort of thing. Obviously, there's good training and safe lifting and all that, but how much time do you spend on that in your position in anticipating and trying to avoid?
Right. So my first reaction on the defenses, I always say deny, and then people like Jennifer and Leslie say, Woody, you can't. You have to accept it. It happened at work. So that's my 30-second piece there. In terms of what do we do is we try to be as mindful as possible in terms of safety committee meetings, making our department available to schools, to departments, and talking about the biggest, what ifs or the biggest injuries that have happened. I even go as far to talk about or explain to teachers how the playground equipment works. I know that seems silly, but when you're able to supervise better and understanding what kids are supposed to do and not do, you're kind of keeping yourself a little bit active and making sure that you are staying safe. You know what to do, what not to do. I wish I could say, hey, we've got people everywhere and we are making the best possible decisions, but I can't be at every location. We have 85 schools, so I can't be everywhere, and I need to rely on employees making the right decisions. And from a defense perspective, once we get an injury, we immediately make phone calls, look for surveillance video, talk to witnesses, all that, so that we have all that information as quickly as possible for our adjusters.
Okay, and Leslie, I want to ask you a question before I do. I don't know if I mentioned, and I should have, Leslie put together an excellent outline of South Carolina workers' compensation that we're going to circulate to everybody who's attending. So that will have a good list of defenses. It'll go through some of the forms. I thought it was a really good resource. And when I was looking through that, Leslie, I saw, and I'm checking it out now too, there's affirmative defenses, there's intoxication, there's the coming and going rule, horseplay. Some of these I think you're probably going to see in every state. How often do you find that something like an intoxication defense is useful? Is that a common thing that you're seeing? Because I don't see it a lot in my state.
No, like I said, I've been doing this 18 years. I've seen and won exactly one. So and the commissioner I talked about who started with me was the one I had the hearing in front of, and she said that it's the only one she's ever found not compensable. So the problem with intoxication is, I'd only have to prove they were intoxicated, which in that case we did he was actually cocaine with a positive drug test. But you also have to prove that it was the cause of the accident. So if someone shows up to work drunk and an anvil falls on their head, that's not going to be intoxication is not going to be a defense. So in the one case that I had, the man was a car salesman and he was walking super fast. And he walked through a place where they were changing oil on cars and just walked through it really fast, slipped in the oil. A coworker went over to help him and testified that his eyes were darting back and forth super fast. And we had a doctor testify that meant he was definitely high at the time. And that really is the only one that I even am aware of. So yeah, it's amazing.
What sort of statute of limitations does a worker face in filing or providing notice?
Sure.
Before they're time barred?
Notice is 90 days, so there are all sorts of exceptions to it, but technically the employee or the claimant has 90 days from the date of the accident to tell the employer about the injury. Now that gets really murky too, because what is notice? If they just said I'm hurt, but they didn't say I'm hurt at work, I wouldn't consider that proper notice. There's all sorts of litigation on that. If it's a repetitive trauma claim, there's all sorts of litigation on what 90 days means. Typically, that's going to start from either the day they first stopped medical treatment for the issue or the day they first stopped working because of the issue. And for an occupational disease, it's going to be 90 days from the day that they were diagnosed with the disease. And then for statute of limitations, it's 2 years, and it's based on the same criteria.
And that, while there's obviously factual issues as far as what constitutes notice and that sort of thing, that's probably, Jen, one of the easier things to track. The stuff that gets a little more murky, I would imagine, I'm looking at the list again, coming and going rule, pre-existing condition, horseplay. Do you find that you're successful in arguing those very much? I'm especially interested in pre-existing condition and Leslie, hernia. How does hernia play into it?
Okay, so in South Carolina, hernia has to meet criterias. And I think in this presentation, Leslie listed them somewhere. Didn't you list the hernia criteria? Mm-hmm. So hernia can actually be defended very well, because if you just grab what she presents and you just hit all of those points, then you can determine compensability. And based on that, you can have a strong argument. Willful intent, horseplay, those actually stand up pretty well too. I mean, if somebody gets in a fist fight because they were looking at somebody else's girl, you know, wherever, whenever, that those, you know, we can deny those claims. And I've never had one of those overturned ever. Coming and going is pretty clear in the statute. So really, it just depends on if they were deviating and why they were deviating. If they were coming and going, then, you know, then like I said, that's pretty clear. So, and pre-existing can get very murky, because pre-existing, we are responsible for aggravation of pre-existing. We are not responsible for the condition itself. So if somebody already has arthritis, our job is to get them back to baseline. It's not to have to correct the arthritis. Where it gets convoluted is that the doctor, most of the time, 80% of the time, will say, well, I'm going to recommend this exploratory surgery because prior to this, we're not treating. And if we subpoena records and they can show that they weren't treating until our injury, then more than likely we're going to buy it. No, regardless, even if you make a baseline, you know, a baseline argument. But please don't feel that that doesn't mean that you shouldn't try, because if the claimant knows that they're not being honest, or it's just somebody who doesn't want to pursue this or actually have a surgery because they know that they really don't need one, then, you know, you can use that, and you can hold doctors to that. We do it all the time. We depose doctors and say, hey, look, you said in the beginning that we were responsible just for the aggravation, not for the condition itself. Or let's say somebody has osteoarthritis and their knee is destroyed, but there's a tear. We're responsible for that tear, not that total knee later. So definitely watch that, because doctors like to do that a lot, and you can hang them on it and you can win. You just have to be very persistent about it.
And Leslie, I'm sure that could have a tremendous impact on the exposure for the claim if you're not responsible for the total knee as opposed to just what was aggravated. That's probably a pretty good outcome for your client.
Right, right. But you will find a lot of attorneys, especially the claims attorneys who've been doing it a long time, they will try to get the doctors to say, well, they would have needed a total knee replacement anyway, but this accident accelerated that need, so therefore you're responsible for it. So it definitely is a lot of who can get the doctor to say the magic words that they need. And those are really good cases to settle. So.
I see we got a question on apportionment, which I think we'll get to just right here in this next section. Before we move away from defenses, I said I was going to ask stupid questions, so here we are. When we're referring to hernia, I'm anticipating we're talking about a spinal disc herniation, or are we talking about umbilical lifting type hernia, or both?
That one. So it's yeah, something in your stomach rips and you can feel it rip and you know exactly when it happened, and it definitely happened while you were doing something at work that caused it to happen. That's what a hernia is, and that's what a compensable hernia is.
Okay, that's good clarification, because that's a huge difference. Woody, yes. I had a question for you about horseplay was mentioned. There's obviously course and scope was mentioned before. How specific are you, either in instruction or in your employee handbook, about as far as the do's and don'ts? And I imagine that would help somebody like Leslie or Jennifer if a claim arises and they want to argue that it was a horseplay situation. Do you try to anticipate that in your training?
So while Jennifer was talking, I kind of chuckled, because horseplay is very much a gray area, right? We want teachers to be involved, but what is the line that we don't want them to cross? In the last week, literally this week, I've had a teacher playing, football with their students tore his Achilles. Is that within your scope of work during recess? Should you be playing with, your middle schoolers? That's where it gets very difficult. I just had one this week where a PE teacher was showing the students how to jump in a big brown burlap sack, and she fell and twisted her knee. These are all things where it's very, very difficult to determine, should you have been doing that? And we lean, I guess, on the nice side, I'll put it that way, that yes, we consider those compensable because you are interacting with students, you are doing your due diligence in supervision and trying to help them and all that. That doesn't mean that I like them, because I have a hard time, you know, with those injuries. And my workers' comp coordinator gets really fired up because she's like, Woody, that is not within their scope of work. And I'm like, no, but they are working, they are engaged with the students, and that's what their job is as a teacher. So, you know, I don't think any commissioner would tell us that that is not considered a compensable injury when it was truly in the scope of being with their students.
So
That was
a
gonna be- yeah.
baseline for that, I'm sorry to chime in. So a baseline for that when you're investigating is if it was benefiting the employment. So if you have a teacher who is playing with students, that's a part of employment. If you have employees who literally are fighting over a candy bar in the break room, that is not. So that's a good way to just kind of think in your head, is this a solid defense? Is it benefiting the employment? If so, yes, and you're probably going to lose. If not, no, and you're probably going to win.
Yep. And I would just add that the victim of forced play who's not involved, there's no defense for that. So I have a case where this guy was working, this guy came up behind him and like tickled him and gave him a bear hug, and it re-injured a back injury and definitely aggravated it. And that was compensable because he wasn't really involved in that.
Well, one other example, Jason, that Leslie and I we've had this in the past, is where a teacher was acting outside of their scope of work and was actually approached a student, and they got in an altercation, and this teacher was placed on administrative leave pending an investigation. While she was on administrative leave, she called in a workers' comp injury saying the student injured her, and we denied that. And Leslie and I kind of went back and forth on it, and I told Leslie, I said, hey, I'm not going to accept this and put any sort of dollar value on that. If a commissioner feels like this was a compensable injury, then they need to order me to accept this. I am not going to put, you know, the school district, the taxpayers' money to pay for treatment or to pay for a settlement when we don't feel like they were acting within their scope of work. And so that is where, you know, maybe sometimes it's a little bit on the risky side because you're trusting a commissioner to make the right decision. But so far we've been fortunate in that sense.
Well, and that's the kind of thing, you're with a public entity and that's going to end up in the newspaper. So yeah.
Well, and you have to set precedents. You can't treat one employee one way and treat another one another way and not think that they don't talk to each other and that won't get back. So sometimes it's worth the fight because you're just trying to show that you're not going to roll over. So you have to set precedents.
Yeah.
For those who aren't familiar, how would the commissioners in South Carolina respond to if Woody was not being nice and he said that the teacher who's I think they were demonstrating how to do a sack race to their students, if Woody was having a bad day and he said, go pound sand, we're not going to pick this one up, Leslie or Jen, I think if I asked 10 claimants attorneys, how do your judges lean, they'd say they're defense oriented. If I asked 10 defense attorneys or claims adjusters, they'd say they're claimant oriented. Did the South Carolina commissioners have a tie goes to the runner approach, or how does
I mean,
it
that would
typically
be
work?
ruled in favor of the claimant. I'm just telling you now. So my job would be to try and talk Woody into picking that up or settling on a doubtful and disputed basis. So a lot of times you can deny a claim, understanding that there's exposure and that you're just going to settle it later. So it could be, look, you know, we don't want this to go in front. I would not allow a claim like that to go in front of a commissioner personally. I would do everything I could to resolve it beforehand and deal with it that way.
Yeah. Well, and I think you have to think about the reputation of the attorney, the reputation of the client going before these commissioners, because a lot of them, they do have reputations for fighting things that shouldn't be fought. So there's this mindset before you even get in there that perhaps you're fighting something that you shouldn't. And I want, when I go into a hearing, the commissioner knows that I'm there for a reason. And I'm not going to bring something that's meritless. I've got an actual argument to fight. And so they will listen when I get there, because they know that if I could have resolved this, I would have.
Yeah, I think that's great advice, because if Woody gets the reputation as the guy that denies everything, then it's unlikely to curry favor in future, contested issues where the commissioners, they're not going to bring up that he was mean 5 weeks ago, but it certainly, people are people, commissioners are people, and that's going to be in the back of their head.
And attorneys are put in a difficult situation too, because they're working for both us, the adjuster, and the employer. So honestly, the adjuster needs to get involved and really try to hone in the direction of a situation like that, because it's unfair to ask your defense attorney to be the bad guy when frankly your job is to educate all parties on what you think, how you think this is going to go. So, if Woody was having a bad day, I think it's fair to say, hey, you know what, let's come back to this. Let's talk about it. Let's think about, our percentage. Will we prevail? Will we not? And let's come back to this. Because a lot of times, if you just give it a minute and you just step back and you revisit it, you'll be in a better position because you've removed the emotion. So
you're not having a bad day, are you, Woody?
Not today.
Woody,
Okay.
You're so temperamental.
I've accepted every claim today.
We got to talk about, I guess, why we're all employed and why we're all here. If it's a real work injury, I'll use the word real loosely, really argued well, perhaps in some situations. So the claimant's entitled to something. They're usually entitled to wage loss, they're entitled to medical. How does that work? What's a South Carolina claimant going to get for a compensable injury?
So first are temporary benefits, and that could include medical care, most likely will. If it gets over 2,500 in medical care, or if they go out of work, that's when you start having to report it. If they are out of work for, it's super weird. If they are out of work for under 7 days, they don't get any benefits. If they are out of work from 8 days to 14 days, they get just the time from the 8 to 14 days. If they're out of work longer than that, then they start getting a check every week until they can go back to work, or there are all sorts of ifs right there. But it is based on the amount of money that they made before they started working. And we call that their average weekly wage. And then it gets subtracted by 2/3, or 1/3, it gets subtracted by 1/3, basically because there's no taxes in workers' comp benefits. So it's designed to kind of put them in the same place they would be in if they had been working. The problem for a lot of Woody's clients is that there is employees, is that there is a maximum compensation rate, which is in the 800s for 2021, I believe. And it changes every year, and it's based on the date of injury. And that's a lot less than a lot of teachers were making before, or a lot of people who, are any kind of higher education kind of thing. So, so that's temporary total benefits. Then if they could go back to work for, say, 4 hours a day instead of 8, they could get temporary partial benefits. And those are the primary things that they can get until they get what's called maximum medical improvement, which means the doctor has said, you're as good as you're going to get. You might need more treatment, but there's nothing that we can do for you that's actually going to make you better. And then he assigns an impairment rating based on the AMA guides. Well, not always, but it's ideal for it to be based on the AMA guides. And at that point, they get some sort of permanent award. And I can let someone else talk about that.
Yeah, let me break that down. Maybe Jen, I'll badger you for a second. Leslie mentioned over $2,500 in medical treatment. You report it. Who are you reporting to? Is it a state entity? Is it?
Yeah, to the South Carolina Workers' Compensation Commissions. So you want to meet thresholds, and if you meet those thresholds, then claims become reportable. So lost time claims that exceed the $2,500, claims that are being denied, anything in which you want to pull them in, claims that are litigated. So there's different thresholds in which you have to report a claim. And 2021 comp rate actually is the first time it ever exceeded its 901, actually. No, it's 903.40. It's 903.40. So we are now over $900 for the max comp rate in 2021. So
okay. So let's use a hypothetical injured worker. They're not going back to work right away. They are out of work. We'll say they're at the 6-month stage. they're still getting, I don't know if it's temporary at that point. When does it shift? When do you look for that MMI opinion? How long do you have to wait, or can you get it as soon as you want to?
So you should always ask your nurse case manager or your doctor or whatever you're comfortable with, or the relationships that you have set up, the attorneys or what have you. I get in the habit of anticipated MMI from the very beginning, right? So if I'm going to approve a surgery, hey doc, how long can I expect this claimant to be out or before they're going to reach MMI? Are you looking at 3 to 6 months, 6 to 9 months? And that way I have something in the beginning, A, for exposure of the claim, and B, to hold the doctor to. Because again, the best way to get what you want from the doctor is actually having them be responsible for what they told you in the beginning. And, they see a lot of people, they see a lot of claimants, they see a lot of patients. So sometimes you just need a gentle reminder, like, hey doc, you said that, 3 to 6 months, we're at 6 months, I'm holding you to it. So
is there, and I'll ask a question from one of our audience members, is there a cap to how many weeks you can get while you're in that temporary status? And somebody else asked about apportionment, and does that apply in South Carolina, and when does that come into play?
So the cap is 500 weeks of benefits. So which is, about 10 years. So it's extreme. I don't think I've ever seen a case where somebody didn't reach maximum medical improvement by then, but that does get into permanency. So if they can never work again, then we're looking at 500 weeks of benefits, unless they've got a brain damage case. But I'm veering from your question. So that's the cap. Did I answer that first question, or was there more to it?
No, you did. And then the follow-up that I threw in there that could be unrelated, sorry. Apportionment, is that once you get the permanency determination? Is that when apportionment comes into play?
Yeah, so I'm not really sure what the question means, because if we're talking about apportionment, so that, let's say somebody was working for the same employer for 10 years and they change insurance companies halfway through, but it's the same repetitive trauma claim with 2 different insurance carriers. There's no apportionment. It's going to be the last carrier of record of the last day that they were exposed. So in that way, there's no apportionment in South Carolina.
The full question is, does it apply for pre-existing conditions, Leslie?
Yeah, let me clarify. I was asking 2 different questions very poorly. The question from the audience is, does apportionment apply for pre-existing conditions?
Gotcha. Yes, it's not super easy, but yeah, if you can stick on the doctor like Jen would, and get them to be very clear, they may have a 30% impairment to the spine, but only 15% of that is because of the cervical fusion that they just performed. Then you have a very good argument that, yeah, they're limited, at least from the starting point, from the impairment rating point, to the 15% that's actually related. But you do have to get the doctor to break that down.
You can make an argument too with a pre-existing condition that if somebody's already treated and been paid out for that injury, that specific body part, like let's say that they were given a 10% and then they get injured and they treat again, but the second time they were given a 12%. You can literally make an argument that you've already paid the 10% and you're only responsible for the additional 2. Mm-hmm. So that's important.
And that was going to be my question that I sloppily called apportionment, which is probably the wrong terminology. What happens when you get that MMI determination? There, in my experience, it's like a whole body impairment rating. Their maximum medical improvement, they have, 17% whole body impairment that all relate to the work injury. What do you do at that stage? What is owed?
So the first thing I would do is request a hearing, because you may, in a lot of cases, be paying them weekly benefits. And if you're 150 days out from the initial day of injury, you can't just unilaterally stop those benefits. You have to get a commissioner to agree to it if the claimant won't sign off on it. So this is the first thing I would do. But what that means is maximum medical improvement means it's time for them to get a permanency award if they're entitled to it. So it's a discussion of, do you settle, do you go to a hearing? But at some point you need to determine they've got an impairment rating, 15% to the neck for their 2-level cervical fusion. And then you have to determine, okay, how old are they? What's their job? What's their education level? What are their restrictions? What are their future treatment needs? And all of those things will come into play when you determine what the disability rating is. And that is not always. It's very, very often, I would say 99% of the time, an increase over what the impairment rating was. And that can, if you can't settle that, that a commissioner determines that.
And a 14B is what determines that. So once they're done treating and they're placed at MMI, the adjuster, the nurse case manager, the attorney, whatever, needs to request the 14B from the doctor. And that actually lists if they're going to need future medical, if they're going to need hardware, if they're going to need medications, injections, and that actually will sink or swim you with your exposure. So you get MMI, you get the 14B. Based off of the 14B, then you can, then you can start talking about your exposure and go from there.
Woody, to the extent we're talking about the indemnity exposure, how important are return to work programs, light duty programs? Is that something that you do that you find useful, or does the system not really lend itself to that?
No, we are very pro return to work on restrictions. When a doctor writes someone out of work, we ask them why. We ask them, can you give us light duty restrictions and allow us to make the determination whether we can accommodate them or not. So most of our doctors know and give us that opportunity. And then it's up to the school district whether we're able to accommodate, whether that's in the same position that they were in prior to the injury, or maybe that's in a temporary other placement where we are able to accommodate their restrictions and they have the education level or the skill level to do another position until they reach maximum medical improvement. So we don't want anybody to sit on the couch while they are trying to get well. We want people to come back to work and feel like they are contributing again as part of the workforce.
Got it. Jen, we didn't talk as much about medical. It's my understanding from our prior conversations that you have some control over medical treatment in South Carolina.
We do. It's we don't have a lot of control of a lot of things in South, but medical is one of them. So the employer is usually the first contact, of course, when someone's injured, and they usually have a provider that they use, and that will be the initial treatment. The adjuster actually gets to direct medical treatment. So you can direct away, you can direct to a specialist. So even if, like, say the employer says, go be seen at urgent care, and urgent care says, we're going to refer you to an orthopedic and we want you to go see Dr. Gal. Well, the adjuster has every right to say, no, I'm going to set you up with an orthopedic and it's going to be Dr. Anderson or whoever you want. So yeah, you have the right to control. With that, once you do, that becomes the authorized treating physician. And then it's hard to direct away from that authorized treating physician if you need an opinion later, because the commissioner will literally use that against you, as in that is your authorized treating physician, that is the doctor that you chose. So if there is anything you can do to mitigate exposure of a claim from the very beginning, I urge everyone to pick your doctors carefully, period.
And to piggyback that, Jason, a little bit too, from an employer perspective, the way that I explain that to injured workers and even at new employee orientation, because everybody kind of looks at you funny when you get, I control your treatment. They don't always necessarily like that. But the way that we explain it is, we have a relationship with these doctors. They know what we need from them. They know what there's a mutual relationship there. And so we're able to assist you get well better. Same with if I assign a nurse case management company, a lot of employees are maybe offended by that. And I just tell them, I'm like, hey, your claim is getting very complicated. Maybe you have multiple doctors on different body parts. We just want to make sure that someone is there to help you, make sure you get to your appointments, that you know which appointment is for which doctor, things like that. And so we tell them that we're able to, from the doctors, get medical notes quicker so that it doesn't fall on the injured worker to provide us updates. We can get those directly from the doctor. So even though us managing care may sound like a negative, I try to explain to our employees that it's to their benefit because we are able to help them, so it doesn't all fall on them to communicate with us what they're allowed to do, what they're not allowed to do.
Right.
Leslie-
And to elaborate on that, I make it clear, that so these are not our doctors. We don't sit and have conversations with these doctors without you present. I can't speak to the doctor without you. There's no communication in which you will not be included in. So it's not like these doctors are calling me and I have a personal relationship. And two, I always talk about money because everybody wants to talk about money. And I'm like, look, it's really important that you use a doctor that understands workers' comp, because if your injury is going to require surgery or disability at the end, you have to have a doctor who knows the procedures so that we can get you to that point. And if you're not treating with a doctor who understands that, then you may not be benefiting yourself financially at the end of this. And when you say that, most of the time they're like, okay, you know.
Yeah, I'm convinced. Leslie, if you don't have Woody and Jen being proactive and aces at what they do, and you have some claims come before you where there hasn't been as much involvement with selecting doctors or selecting good doctors, you're at the litigation stage. Are you stuck with that? Is there anything you can do through the commissioners to try to, take control back over the medical treatment or get with a better doctor? Or are you kind of faced with what you got?
You can. It's not easy. So the first thing you can do is get what's called an independent medical evaluation. And just say you've got somebody and they've just been treating for 6 months for a toe injury, and they should have been released by now. You can get an independent doctor to give you an opinion on whether they actually need more treatment. The problem is always going to be the commissioners are going to give more weight to the doctor who's been seeing them for a really long time. So we're definitely at a disadvantage at this point, but you certainly can. And I certainly have seen many cases where we've had to switch doctors for one reason or another. We had a doctor we used all the time who is an orthopedist for the back, and he went out with his own back surgery for a year, and we had to switch a bunch of people over. So, I mean, that's a different thing than taking control, but it certainly does happen. You just have to be prepared that if they have a claimant's attorney, it's very likely that if the claimant is happy with the doctor and they're not happy with the new one, you're going to be at a hearing over that. And you're just going to have to be prepared to explain to the commissioner why this new doctor is better.
Okay, I want to try to move forward, catch a couple more topics. One of the bullet point was forms in quotations, which I figure we spent about 90 minutes on that or something. No, when we brought it up when we were preparing, we said forms, and Jen said, the employers aren't going to care about that, and Woody jumped in and said, I care about that. So, Jen, give us the general overview. Forms are important. You can get in trouble if you don't send them out. What's the
Oh yeah,
situation?
forms are very important because you can be fined if you don't file forms appropriately or timely. So that's very important, right? Because you don't want to be that person who's costing your employer money. So very, very important. Now, some forms do require that the employee be involved directly and some don't. And then some employers require that they be involved in all of it, and some don't. So really, you need to make sure that as an adjuster that you're aware of the forms in each jurisdiction and what requires the form. And we could honestly spend an hour talking about forms. So Leslie created a nice little recap. Just make sure that you have it and that you're filing forms accordingly and timely, especially those 15s and 18s, because those are the ones that are generating fines the most. And a commissioner will straight up tell you that they depend on those mistakes for their revenue. So it's that big of a deal.
Yeah.
And Woody, why do you want to get involved in this incredibly important but seemingly boring stuff? What's your take here?
Well, notice how when she said employer, she rolled her eyes at me, Jason, first of all. So let's start there. No, I can only speak for the school district and how I've been trained and the things that I have learned. And maybe we are a little bit more hands-on than some other employers. But I just like to be informed. When the 14B comes in, I'd like to know what the ratings were. When we settle at an informal conference, like I said, I'm there most of the time with the telephone conferences now that makes it a little bit different. But, you know, when the commission approves an informal conference and then the Form 19 has to be signed, I tell my adjuster, send the check and the form to me because I want to deliver that check to the injured worker. I also have this silly little gold star stress ball that I give to my employees when they get injured, and on there it says, "You've reached the finish line. Congratulations." The workers' comp process can be a very frustrating and difficult insurance claim, right? So the last thing that I want employees to remember is my employer gave me a check and a silly little stress ball, and I'm smiling about it now, versus this was a miserable experience and I don't feel like my employer did anything for me. I want them to remember the good part. Now, I only give those to employees that don't get an attorney.
I was going to say, I might want to move to South Carolina and work for Woody's,
Nope.
giving out.
No stress ball no stress ball star if you got an attorney.
That's it.
Leslie, we won't be able to go in depth into it, but we had another bullet point for, you know, the common litigation process. I think perhaps what might be helpful for our audience today, what are you doing most of the time when you're in court, be it virtually or, you know, in person? What's the most common sort of fights that you're having, separate and apart from the settlement process? What are you seeing more often than not?
Sure. That's a good question. I think probably most are just about permanency. So just about how much is this person entitled to? Are they permanently and totally disabled? Do they have a brain injury that would entitle them to lifetime benefits? Is it just a shoulder, or is it the shoulder and the neck because it's hurting the neck? Those sorts of things, but it really comes down to how much money at the end of the case. But I mean, there are so many other things, obviously, that I've certainly had cases, many cases that were just complete denials, and we had to go argue that. Change of condition claims, we have a lot of those where they have to prove within a year after their initial settlement or their initial award that they have gotten worse, and they have to prove a physical change of condition for the worse. And there's all kinds of litigation on that.
Do you get to, and I don't mean to interrupt, but you mentioned permanency. Do you get to select the doctor who performs the permanency evaluation, or is that appointed by the state or someone else?
It's almost exclusively the doctor who's been the authorized treating physician the whole time. Now, I've certainly run into cases where, for one reason or another, they've gotten with this doctor who doesn't do comp and just refuses to do an impairment rating, and we have to get an independent medical evaluation to get that. Also, there are doctors who are more conservative than others about how much they rate. So if I had a case where a person had surgery and got a 2% rating, and the attorney on the other side got their own independent doctor to say it should have been 20%. So, you know, those kinds of things, but it's always paid for by the carrier or the claimant themselves.
Which is why Jen said, be careful which doctor you select, because
yes,
I can't say it enough. It's so important. And it doesn't, you know, you can pick the best doctor in the world and still not have the outcome that you hoped for. But at least if you don't get that outcome, you can say that you tried. You know, you can tell Woody, and you can tell your managers, and, you know, you can tell people internally, look, you know, I attacked it from the very beginning. We just didn't win this one. It happens.
And then just to wrap up, and I think it's a good thing to end on, settlement. I'm injured. I work for Woody. He gave me the stress ball. That was super nice. But I think I'm oh wow. I think I'm legit injured, and I'm never going to go back to work and do the potato sack races. So I want to settle out my claim. So what's the process? How does settlement get started, and who has to approve it, if anybody? What goes on?
Well, first it depends on whether they have a lawyer or not. If they do not have a lawyer, but they still work for the employer, we request an informal conference. And there's just a little conference between the deputy commissioner, somebody who represents the employer, and the claimant. They make an offer on what's called a Form 16 settlement, which means it's not closing out the case. So it's not going to be a huge amount more than what the impairment rating was, and medicals are left open. If they do not work for the employer anymore, then we still need a settlement conference if they're not represented, but we try to close those cases out on what's called a clincher basis. And that's when you go to the jurisdictional commissioner. Of course, we talked about that before. If they have an attorney, then it can just be me talking to the claimant's attorney and we get it resolved. And that certainly happens a good bit. If we can't get it resolved, we go to a hearing. And if it's a case where it's super complicated, we actually have a mediation regulation, which says there are certain cases that you have to mediate. And those would be cases where, in any case where they're alleging that they're permanently and totally disabled, which happens a lot, and those are the vast majority of the ones that end up being required to be mediated. If there's a stress injury, if it's an occupational disease, if they have a longshore component to it, which means it's a federal claim, so they're all, or if just a commissioner orders it, they just don't want to hear the case. They can say, no, you guys have to go try to mediate this. We're never going to be required to mediate a case that's denied, but otherwise, pretty much anything can be mediated all the time. What are you going to have one tomorrow?
Yeah, Jen, is settlement the typical outcome of a claim that doesn't go away, otherwise within the first couple of months? Is that usually where you end up?
So settlements are usually the only outcome in litigated cases. The majority of the time. Now, you can win if you're fighting a claim all the way through. You can win so that there's not a settlement. But again, that can get costly and it can get litigious. So, my approach to any claim is mitigate exposure, right? So whichever avenue you're going to go, you need to always keep in mind, or at least I always keep in mind, that which way can I mitigate exposure best? Is it going to be settlement? Is it going to be hearing? Because sometimes people just don't want to they just don't want to settle. A lot of times your employers just don't want to settle. And I respect that. I get it. It's frustrating. But at the same time, I'm not that, we don't want to pay Leslie, but we're going to pay Leslie a lot of money to defend our claim. And most of the time the claim, to settle could be less than what we would even spend in defense costs. So it really is the adjuster's job to make sure that they're mitigating the best way to resolve claims. And then with settlements, there's a lot of components. I mean, you have Medicare exposure, if you've got perm total or you've got catastrophic claims, you should consider annuities, stuff like that. So, but yes, settlement is usually the outcome.
Yeah,
Yes.
Woody, we don't want to make a recording of you saying that you'll settle any alleged injury that comes across your desk, but do you take Jen's advice to heart? Is it sometimes more practical to try to close it out sooner rather than getting involved in lengthier litigation?
Yeah, unfortunately. I don't say that to be ugly, but Leslie and my adjusters will tell me, hey, Woody, it makes more sense to settle this than to try to fight this. And that's where I need to, as a public entity, I want to make sure that I think through that, so that if I am if my workers' comp settlement is requested through a Freedom of Information Act of what settlement I paid, I want to be able to make sure that I have a reasonable explanation why I paid something versus why I didn't go to a hearing or a commissioner or something like that. So I have to weigh that a little bit, but a lot of times I will Jennifer, my adjuster, Leslie, an attorney, we will have those conversations pretty early on to determine that. And there are times where I have told my adjuster or my attorney, hey, we're going to fight this because I am not paying this based on the alleged injury.
Yeah.
And Leslie, there was one more question, and I think this will probably wrap us up, but we might as well address all the questions if we can. And I see only about 6 or 7 people dropped off. So you guys are super interesting. The question is, does an employer have to agree to a settlement with a claimant, or can we, which I assume in that instance is the employer, do it without their approval? So I think what they're suggesting there is if there's a value for the claim, can you pay that out unilaterally, or does it always have to be something that's a negotiated agreement? And I guess to top that off with my own last dumb question, are these settlements approved by the commissioners, or is it sort of we came to what we came to and let's put it on paper and call it a day?
Again, it depends on whether they have a lawyer. If they have a lawyer, it has to, we have to actually have a settlement conference. If they don't have a lawyer, if they do have a lawyer, it still has to, the paperwork still has to go to the commission, but they don't even look at it. It just gets stamped and sent back.
And I'm rereading that question with my other half of the brain working. And I apologize to the person asking the question. It's a legit question, and I'm a dumb person. What they're asking, if I'm reading this right, I believe it's probably an adjuster or somebody from the insurance company. Jen's nodding her head with my stupidity, asking if the insurance
No,
carrier.
that's
With the question, we're
Yeah,
nodding
okay.
our head at
No,
the
with the
question.
so that's a difficult question to answer because it literally depends on who you work for. It depends on your company. There are some companies, I mean, I've been doing this a really long time. There are some companies who say you're the adjuster, you make the final decision. There are some that say you need to make sure that you and the employer are on board with the final decision. There are some that say the employer, this is the employer's money, the first half of it, they get the final decision. So that's a difficult question because it literally depends on your accounts, who you work for, and what your internal processes are. So you should always just try and be on the same page. I mean, your attorney, your employer, and yourself. But I get it. I've been doing this a long time, and you know, you have resistant employers, and then at that point, I would urge you for you and your defense attorney to get on the same page, because what happens usually is that the two of you have to do the work to convince the employer, because at the end of the day, it's usually going to be what the adjuster and the defense attorney decide. But you may have to involve agents, internal people, you know, so.
Yeah, to agree with that really quick, Jason, I think it depends on the way the employer is set up with their adjuster, with their TPA, anything like that. We are self-insured, so any settlement needs to be approved by me. But that depends on the employer and how, you know, they want to handle and what their practice is. If they're a fully insured employer, then more than likely the insurance carrier will make the decision along with the adjuster versus the employer having any sort of say.
Yeah, and if I'm interpreting Jen's comments, it sounds like there's probably situations in which you could, as an insurance carrier, you know, settle the claim because it needs to be settled, and the employer probably doesn't have any say in it. But obviously, as a best business practices approach, the more you can do to convince them that what Leslie's recommending, what Jen's recommending is the right thing, is probably in your long-term best interest in maintaining that relationship.
Yep.
So
Exactly.
in our hour and 8 minutes, did we miss anything glaring on South Carolina workers' comp?
I mean,
We
there's
just
more we could talk
skimmed
about,
the
but
surface.
yeah.
Well, I want to thank you guys. You guys are awesome. I think I was probably unneeded, but it was an interesting look from afar, and hopefully useful for our attendees. The outline from Leslie will be coming around. If you have any questions, certainly reach out to Leslie. You can also, somebody's raising their hand. I don't know. You can also email us, go to the Chartwell Law website, and we're happy to talk to you about all the states we work in, but specifically in South Carolina. Talk to Leslie. Don't ask me because I don't know a thing about it. But you guys are awesome. I hope I can talk to you again sometime.
Thanks, Janet.
Thank you.
Guys.
Thank you, Jason. That was great. And thank you, Woody and Jen, for being willing to do this. I appreciate it.